I would like to start very, very quickly, just going through backwards in what we have touched upon last time, just to recall some of the basic issues. And then because it's part of what we're talking about today, everybody who has been there or not been there are placing the, let's say, our lesson today in the right environment, let's say, put it this way. Okay, so I will talk today about the Dublin regulation, which is one of the, let's say, most important pieces of the European asylum system, because it is affecting a lot of people, and why it is like this, we will come to it in more detail. But let's, before going backwards a bit in recalling some of the most important points from last time. I said that for a full right of asylum, it would have to comprise different kind of components, which unfortunately are not fully, let's say, implemented in Europe, especially when we talk about the admission of persons to the territory. That's unfortunately is not the case, but this is something that in theory we would recall as the so-called 5 steps to full rights of asylum. So be admitted, allow a person to stay in a country, refrain from expelling a person, extraditing a person, and also prosecuting or punishing a person who is just coming for seeking for protection. What is important to recall, and I'm going very quickly because I don't want to be repetitive from last time, is that we have a very interesting but also very complex overlap of 5 simultaneous and often really overlapping legal regimes. We have the international refugee law, which is the Geneva Convention mainly, the international human rights law with all the different human rights instruments. We have the European Convention of Human Rights as a regional human rights law with its protocols. And then we have the Common European Asylum System, EU law, European Union law, and of course national law. And all those interact in a certain way, which makes it very interesting, but also very complex. Major point is the definition: what is a refugee, which is defined in the Geneva Convention. It defines a refugee as a person who is outside of his or her country of nationality or habitual residence, has a well-founded fear of being prosecuted because of his or her race, nationality, religion, nationality, membership of a particular social group or political opinion, and is unable and unwilling to avail himself or herself to the protection of that country. So is seeking for protection, basically. As I told you, lawyers like to have this kind of click boxes. These are the kind of 8 conditions that is inside of those of this refugee definition. You will have available all the PowerPoints, so that's something you can refer to afterwards. When we come to the EU asylum system, I would like to recall the basic instruments, the legal instruments, quickly. We talked about those are more related to the, let's say procedures or reception conditions. These are the reception condition and asylum procedure directives. This is 2nd generation already. In 2013, have been readopted with some new features. And then we do have, which is an instrument which has never been used before the Ukrainian crisis. We talked about this in detail last time. Is the temporary protection system from 2001, which has been first and only once applied and activated in 2001, which is very important for the legal assessment, are the directives of the so-called qualification directive, which defines very precisely and recall also the Geneva Convention in this regard. What is a refugee? And it's more precisely though, so it could be very interesting also for you to read what the directive says when it talks about the refugee definition, because it's a bit more precise than this definition that we have just gone through in the Geneva Convention. This directive is so-called qualification directive, which is Directive 2011/95 of the EU, is also a directive that's opened up a subsidiary protection scheme, which is a supplement to the refugee status, basically meaning that a person who is not granted refugee status because it's not individually prosecuted may not be returned, however, for specific violation reasons, because fearing this person might feel being harmed by an international conflict that is taking place there. So this directive is open up for a subsidiary protection scheme, which is an additional protection scheme that has been opened up by the European law. And now we come closer to what we're talking about today. It is basically the so-called Dublin regulation. This is something that is, as you can see, it's often called as the Dublin III regulation. It's the third instrument that has been implemented on Dublin. I will talk about this a little bit later. But this is basically a very, very rough definition. It's a sort of entrance regulation. So before you actually examine an asylum request by an asylum seeker, so asylum seeker comes to the border and says, hey, don't push me back, or don't harm me, I need protection in your country. And from this single moment, the law says that this person needs to be considered an asylum seeker and then needs to be protected. But before a country in Europe is going through the asylum procedure, so individually assessing whether this person is prosecuted in the country of origin, the EU country is doing a check whether this country is, or its country is responsible for the asylum procedure as such. And this is the Dublin regulation. There are some criteria, we'll come to it later, explaining exactly who is responsible, which country is responsible to fulfill the asylum application. So assess the asylum application and do the asylum procedure. Okay, so this is what we're talking about today. It has been in the last years one of the most discussed and potentially also criticized legal instruments at the European asylum system. That's why I think it is also that's why we actually, as we decided the program for this course, that we thought that might be very important to enact a specific class only on Dublin, because in fact a lot of people that are working in the asylum system in different countries are at one point or another very often concerned and related to the Dublin system at some point. Okay, another regulation which is important to highlight here is the so-called Eurodac regulation. These are, you can see it from the numbers, have been adopted always in conjunction, because the regulation of Eurodac is basically a database, a European database established through this regulation that that would register all the fingerprints of asylum seekers in Europe, and makes it then available to check whether a person has been entering in a country first before applying for asylum in another country, for example. Okay, I think that's basically my quick going back from last week. Let's enter straightforward now in what it actually is, the Dublin regulation. Here you can see the adapted list of the Dublin states. You can see all the states. The UK has been part of this, but is obviously with all the Brexit going out. So you can now see that we have 31 different countries that are so-called Dublin states. We are not only talking about EU states, but we do talk about Dublin states because it's including also countries like Norway, Switzerland, inside, or Iceland even, inside the consideration of the Dublin. They all adopt the same Dublin system. Okay. What is Dublin? In a nutshell, you could say that is, as talked about this already, a legal instrument of so-called common European asylum system. It is, as I told you, it is sort of preliminary procedure. So before actually going into the asylum procedure, before it really starts with the asylum procedure, then the Dublin states will check whether the Dublin state, the country in which a person asks for asylum, is basically the country also responsible for the asylum application. What you can, let me just open up a small bracket. What you can see here is that basically through the Dublin system, the European states, or the Dublin states, if you want, they started up to limit the access to asylum through the Dublin system. Why I say this? Because usually this is the obligation from the Geneva Convention. It was as soon as you, and this was all these countries in Europe have signed this convention, as soon as a person would ask for protection, this person would then receive the obligation, let's say, by states to go through the asylum application and to make an individual assessment of whether this person needs protection in the country or whether not. By establishing this Dublin system, basically a country can say, I'm not examining your asylum application because you came through another safe country. And that's why I'm sending you back to this safe country, and you can do your Dublin system over there. We will see that this concept is based basically on an idea which is considering Europe as one big state to some extent. And you say, okay, well, we just sent you in the region where you should go into the asylum application. But as you all know, that this is not a reality in itself, and that creates a lot of problems in practice. But we will come to the criticism of this in more detail. But that's why this has been also criticized a lot, because in fact, the limitation of the asylum system through the Dublin system is basically something that comes with a lot of criticism by NGOs, scholars, and so on. What is also important is that we have different Dublin units that would cooperate and would enact the different Dublin procedures. And these Dublin units have been established in each country, and they are cooperating in a way to smooth this sort of Dublin system. And you can see the Dublin regulation is currently regulated by the Dublin III regulation, which has been readopted in 2013. Why 3? Because we have first started with one convention. I will come to it a bit later when I talk about the history of it. And there has been a first Dublin regulation, the so-called, so Dublin Convention was a Dublin 1 system. Then we had Dublin 2 regulation, which was already an EU instrument. And now we have a sort of adapted Dublin 3 regulation. There has been a proposal of a Dublin 4 regulation, which some changes, which this has been proposed years back already, but has never been adopted. Why the Dublin procedure has been used? Here we have to go back a bit in history, but also recalling some of the problems that has been let's say observed in the European space. First of all, there has been the idea that the Dublin system needs to be established in order to fight against the so-called refugee in orbit phenomenon. That means a person who is asking in one country an asylum, but this country is not really prepared or not responding, not enacting the asylum procedure, would left herself in a certain situation where nobody is really taking care of it. And this happened effectively in Europe quite time ago. So it was a sort of response to the Dublin procedure, was a sort of response saying, at least we determine which country is responsible, and this country needs to take up the asylum procedure. Also here, I will take you through some let's say episodes of history where this is actually showing that the Dublin system in this sense also is not really working very well. The other part is it was very clearly said that European countries wanted to avoid that there is a sort of asylum shopping. So countries, so asylum seekers that would go to those countries where potentially there's more social benefits, or they are not, the conditions are better, you have better work conditions as well, etc., etc. So from the beginning, it was also the idea that European countries would all provide, and this is sort of idealist approach, would provide the same sort of protection. So persons should also go back and doing the asylum procedure in the country, which would be the first country for them to ask asylum for and receive protection. And then, of course, and that's one of the main reasons, and I will talk to you on this sort of history quickly, because I think it's very important to connect to the actual Dublin regulation, this kind of historical fact, because it has been sort of a prerequisite for the European free movement of persons zone, the Schengen zone. Without Dublin, Schengen would not have existed. Let's put it this way. So let me have a quick going through a quick excursus why I say Schengen has been sort of the important motivation also for the Dublin regulation. Let's go quickly. The two instruments here, the Dublin regulation, which from Dublin, and the Schengen, the small picture of the small village in Luxembourg. are really straightly connected. Why is it so? Because you have to know that when Schengen, first of all, has been discussed in 1986, some countries, not all countries of the European Union or the European community at those times, actually got together and said, let's establish a free movement zone where border controls are completely abolished. That has mainly the countries at those times have been the Benelux states, where this kind of free movement zone has been already established. They had no border controls anymore. So Belgium, Netherlands, and Luxembourg, and they wanted to extend this to the markets, let's say, also of France and Germany. And as soon as they discussed this issue together, they also identified it as the most important step forwards to a more integrated internal market, because one of the big issues were that all the let's say big trucks with all the goods had been controlled still at those times at the internal borders, and they wanted to avoid this and made it more free to move, and the same for persons as well. So when they discussed it in 86, one of the big issues came up that yeah, we want persons to move freely, especially those who are living in the European Union, or let's say at those times in the European community, especially in those countries. They want to freely move, but we don't want that the migrants move. So migration law at those times has not been harmonized at all, and we don't want especially asylum seekers to move. That was one of the reasons why in 86 they thought, okay, let's discuss this issue of asylum as well for a second, so that we get it clear in the next years when we establish a Schengen system, also for the asylum system. And they came up with a system, and this was also fueled by the fact that in the late 80s, a number of, and in the early 90s, a number of refugee flows has often been seen in Germany, for example, and so on. So Germany was at those times one of those countries that specifically said, I don't want to bear all the asylum applications. I would like to establish a system where we have a clear system of asylum, etc. So asylum was on the core as well of the Schengen system. And you can see it very well the moment when all these countries came together in 1919 to sign the Schengen Agreement. They had, first of all, in the same week, but some days before, met all together in the Schengen, in Dublin, to sign this Dublin Convention. At those times, it was not a legal instrument of the European Union or the European Community. It was an instrument that has been established as a convention between states, so an international law instrument. But this Dublin Convention has been 5 days before the Schengen Agreement could be signed by a limited number of countries at those times. Still, Italy was, for example, not part of it, just to make this clear. Or Spain, they all came later. And but they had to enact the Dublin regulation before, otherwise the Schengen Agreement would not have been signed. And the reason is clearly that the idea was to create a Schengen area where there would be looking like this, basically. There would be no internal border anymore. Now it looks like this, roughly. It's not reality because some 8, I think at the moment, internal borders have been re-established. But basically that's something that you may recall from that Schengen area has been created. But with the Schengen area, we also created external borders, which has been have been enacted in particular sense for providing the, let's say, the security for the states to open up the internal borders. And by doing so, the external borders, the asylum question came into more and more into the, let's say, the discussion point, because it was the question what we do with those people coming at the external borders and asking for asylum, or coming through other kind of means and asking asylum in the European Union. That's why Dublin has been established. Let me continue discourse by telling you also some of the issues that have been also forced countries to enact the external borders in a different way. One of the incidents was 2006, where this kind of situation, people in the Canarian Islands had a lot of those kind of boat peoples on the Spain, on the shores of Spain, which actually provided, here you can see some of those movements, either from Morocco to Spain, to the offshores there, or to the Canarian Islands, which happening again in these years quite strongly. But this, through the pressure of the different states, the other European states, the Schengen states, Spain was forced themselves to establish clear borders on the two enclaves, for example, in Ceuta and Melilla. You can see it very strikingly what happened after these incidents in 2006. They, instead of having a real human approach, let's put it this way, they open up a very strict fence system. And you can see how it looks like, 6 meters, different kind of areas, etc., which has also been enacted by razor wire, for example, which is quite harmful. Do you know what this is? I mean, you can imagine, I guess you can, from the butchers, you know it. But in Morocco, the immigrants in Morocco, they call it the visa, because they climb with it through the fences when they try to overcome those fences in Melilla or in Ceuta, like it happened, for example, in June, where a number of people actually died as well. I just recall you one case which shows how now our, because this is an important case on the external border, shows how violent even our sort of legal system has become. So the case of ND and NT versus Spain was 2 persons trying to go through Melilla to Spain, has been pushed back to Morocco, and the European Court of Human Rights decided that this was not a violation, although the pushback was quite evident. There is an interesting video that you should, if you haven't seen it, you should see on it. It's very interesting, explaining the entire case, but also legal reasoning by the court, and make a good criticism about the system that has been, or the decision that has been done by the European Court of Human Rights. This video is done by a forensic architect. You can find it quite easily. This is a very interesting point where you also can see what's happening with the external border. But how is this connected with the Dublin regulation? It is because European countries, especially those who are now not entirely on the external border anymore, forced those countries on the external borders to enhance a very strict external border system. Also because they don't want too many asylum seekers to come. And the Dublin regulation is a regulative that has been established to, let's say, allow the Schengen system to exist. I think we said that I would go through another 5 to 10 minutes, and then we do a small break as announced by, and then we also, I will open also some questions, but let me just go quickly to some basic principles again through the Dublin system. Or is there any big question that has been raised already? Because I haven't seen the questions. Maybe.
You want to? Sorry, do you want to respond to some question right now or after all the lessons?
If there are some burning questions to what I have said now, we can also touch up those questions right now.
Okay. Do you want to pick up some questions or?
Just looking, because I'm seeing flowing in questions and I thought I just
yeah, there are a lot.
So let's say, so yeah, Lorenzo said, is there any conflict in international EU and national law for refugees which could be overruled? Yeah, of course, there are a number of questions always, more linked to, this was a question by Lorenza, more linked to the practice of EU law or a national or refugee law, rather than to the different legal instruments. But even the legal instruments sometimes can have been, but then it's obviously there is a sort of hierarchy of legal rules. So the international and then international rules would certainly be the sort of key point to look at. And of course, the EU law, but also the national law has to be in line with the international rules. So maybe that makes it clear. We will come to some examples of violations where you can easily see how actually they conflict, and often it's linked to national practice or sometimes even some national regulations or tools. So yeah, overruling is possible and should happen. Then in practice, obviously, that's difficult. So other question from Abu Bakr. Where is it? Yeah, let me say all these questions to the Dublin regulation. We will see it a bit more later when I'm talking about the Dublin system, because I'm just introducing sort of the context. Question of why Dublin 4 has never been adopted. That's a good question from Nora. The proposal was an interesting proposal those times by the European Commission. Especially it has been interesting how, for example, the European Parliament, who adopted already its opinion those times, has approached the Dublin system. All came after the 2015 so-called refugee crisis, which is actually a refugee or European asylum system crisis rather than a refugee crisis, because the system couldn't really adapt to the persons that are coming through the system. And you know, a lot of those persons, I remember Angela Merkel, for example, saying in 2015 that the Dublin system is dead, it doesn't work, etc. And in this kind of ideas at those times, the European Parliament proposed that it's not ideal for the European Parliament to vote in all fledged, but it's quite interesting what has been proposed, because the European Parliament opted for a system where people could choose where to go. So the wish, let's say the person's interest and let's say considerations were also taken into account, which at the moment, you will see it later, is not at all. So given this situation, it is clear that some member states had some problems with this position from the European Parliament. And very funnily, it was at those times Salvini as Minister of Interior from Italy, who opposed strongly against, let's say, the approach of the European Parliament. Very interestingly, because this approach from the European Parliament would certainly taken away, as an interest of Italy, taken away a lot of those asylum applications from Italy, because a lot of people didn't want to stay in Italy. They want to go further, and etc. So I think that was very interesting to observe. And then at some point, the system has been completely, so member states that didn't really took it up. I see somebody raised their hand. Right. Is it, or is it just me just seeing it? Maybe not. Okay. Let's
so
continue.
we want to do that like 10 minutes break and next restart, or?
Yeah, let me before we break, if it's possible, just to go to the principles quickly, and then make break.
Okay, perfect.
Okay. Let me just close this down. So let me just quickly go through these principles of the Dublin procedures. The idea behind the Dublin system is that only one single state would be the Dublin state, would be the state where the asylum seekers will be following the asylum application. So then there'll never be 2 or 3, so it's only one. That's the idea behind. Then we will see that in practice that's also not working very well. The negative recognition is something which has been criticized quite a lot, meaning that the Dublin system mutually recognize all the negative asylum applications. So if somebody is rejected, somebody's asylum application is rejected, then it is valid in all Dublin states automatically. But what is very bad is that the positive way, so if you do have a positive outcome, then it is not mutually recognized. So if somebody has a refugee status, that's very important to highlight, then the refugee status is valid only in the country which provides the refugee status. For example, somebody who's doing the asylum application, the entire asylum procedure in Italy, and receives a refugee protection or subsidiary protection, this protection is only valid in Italy. The person can move when it has travel documents to another country, traveling in a way of visiting the other countries, but cannot establish itself with the status that the person received in a second EU country. So that's very important to acknowledge that you have a negative recognition, but you don't have a positive asylum decision recognition in Europe. Dublin criteria is very important. We go through it quickly afterwards. So the member states that are checking who is responsible for the asylum application through a provided list of Dublin criteria. And these are highlighted in a hierarchical sense. So you have to go first to the first criteria, second criteria, third criteria, and only if this third criteria is not possible, then you go to the fourth criteria, and so on and so on. Okay. And the last point is, so you check who is responsible, going through the hierarchical list of criteria. And as soon as you establish who is responsible, in the ideal situation, this asylum seeker would then be transferred to the country of responsibility for the asylum application. Again, this is in practice quite difficult, and we will talk about it a bit more. Okay, last point, and then we make a break. as you can see from here, this is from 2015, but it could be, you know, I couldn't find another map which is more explicit on this. But I think it's showing you also quite interesting how actually the Dublin system does work in a certain way. So, for example, a lot of those migration flows come through a certain way using some routes. The routes of Turkey to Greece, for example, which was the most strong route in 2015, but also Libya to Italy, but also now more and more, the Western Mediterranean route, Morocco, Mauritania, Senegal to Spain. So these are the sort of classical routes. Now, of course, with the Ukraine crisis, a lot of those refugees, temporary protection beneficiaries coming from Ukraine, obviously. So all these kind of migrant routes are routes that in a certain way have a first country of entrance for those people, but then they move on in different other countries. As you can see, Germany is in the absolute middle here, not having any clear first kind of attachment to the external borders. But the person are seeking asylum in Germany quite, or at least in 2015 they did, and they usually do quite importantly in Germany, or like in other countries like in Sweden. And so that means that there's a secondary movement that happened. And those people can, after certain criteria, can be sent back to the country of first entrance, or the country who is responsible for the asylum application. So that's just showing you how this kind of system works. But now we do a small break, and let's go back in 10 minutes.
Yes, we will start in 7 or 5 minutes. It will be okay?
Perfect.
Okay, thank you. Someone raised a hand, but I think that we'll respond to all the questions at the end of the lessons. If
Okay.
it's okay.
Yeah, let's do this way. If there's some urgent questions, let's put this way, because I think I'm not able to check at the same time all the different questions. So either you see something very striking as a question that might be fitting to ask immediately, then just interrupt me, and then we can take this question. Or somebody really want to say something on a subject that I'm touching about in my presentation, then please raise a hand, and then I stop quickly, and then we can address it. Okay, let's do this way. Otherwise, I'm difficulties to follow all the different things. Okay, let's go back to the slides. I have to find everything. Okay. Okay, you should see them, right? Good.
We can see the...
Okay. So yeah, I'm going through something more technical now, which I hope will not be, will be, however, interesting, because a number of these issues might be, if you are activist in the area of refugee protection, you come to most of these items at some point or another. Or if you become somebody who wants to help asylum seekers in a certain country, that be in Germany, that be in France, in Italy, or in Spain, or wherever, you will come at some point to these very practical questions of Dublin procedures. So that's why I think it's useful to go through the different procedure items, even if it's sometimes a bit boring. What is important is that the application for asylum and the indications so we look at the asylum procedures on the specific indicators that exist. I'm a bit lost now. So yeah, what is important to note here is that asylum application can always be done only in one country. And that's what we are doing in this sort of asylum application and asylum Dublin application system. There is the Dublin unit, as I said already, who is initiating the Dublin procedure. So as soon as an asylum seeker is coming in front of an asylum, let's say, authority and a member state's authority, and say, I would like to express my request for asylum, or is registrating an asylum application, then as soon as there are indications of a person who is coming from a sort of safe country of some of those Dublin states, then the Dublin's procedure is enacted. And this is then initiated by the different Dublin unit. And only then the asylum procedure can actually start. So that's sort of what I wanted to say here in the kind of first way. So you need a sort of indication that a person comes from another country. Now, which country is basically responsible? These are checked in different ways. First of all, you may heard something which is out there as in practice as the most important criteria, but it's basically not the most, let's say, the most up hierarchical criteria for the Dublin regulation, which is the first entry country for deciding which country is responsible for asylum applications. You always have heard, I think, as soon as you enter in a country first, then this country will be responsible for the asylum application. Here, I will present you the different criteria in the way how they are presented in the Dublin regulation. First of all, as soon as you are a non-accompanied minor, it's very important to recall that the state where the minor is residing, or if the minor has family members in another state, this country is basically responsible. So it's not about, for an unaccompanied minor, we're not checking which country this person came from first. Here we're checking only if this minor has family members in another country, or if not, then it's the country where the person is physically staying in this moment, who is responsible, which is responsible for the asylum application. That's very important because you do find a number of minors, and of course, minors, let me just recall it, are persons, for example, also that may not look minor, but persons that are in the age between 16 and 18, and this is something which happens quite often as well. So as soon as you have a minor in your sort of practice, then be sure that the Dublin regulation as such applies, and make sure that this country is responsible for the asylum application if there is not another family member in another country. In terms of adults, the situation is a bit different. So first criteria is if you do have family members in another country. So it's not the criteria whether you started to come in a country, which is actually the first criteria. The first criteria is if you do have a family member, then this country is responsible for your asylum application. This is to say, it is a bit tricky also because the fact that the family member definition is quite strict in the Dublin regulation. It's only talking about spouses or partners, minors, or specifically also parents. So direct line and responsibilities, basically, that's another point which is important. So if you do have a responsibility and tutorship, a guardianship or over a person, then this may also be subject to this criteria. So that's the first criteria. If this is if this is happening, so you do have a family member somewhere else, then you are allowed to apply for asylum and do the entire procedure for asylum in the country where your family members are living. The second criteria is whether a country is giving a visa or a residence permit to a person. Then the link is considered to be as tight as possible, that also asylum applications should be going through this country. So for giving an example, if, for example, a person from Afghanistan got a visa for Germany, but going through let's say the classical route at the moment through Turkey to Greece or Bulgaria, then it is not the country of first entries, Greece and Bulgaria, who is responsible, but it would be Germany, because at some point Germany has given a visa to this person. Okay, then and that's the one that you most particularly know and have heard about, is the irregular entry and stay. So if you are registered your entry in a certain country, the first country of entrance, if you want, is then the one who is responsible for the asylum application. That might be also tricky in the situations where it is in transit zones, and then it is the country where the transit zone is linked to where the asylum application is to be fulfilled. And if all those criteria are not going through, then the first Dublin state where an asylum seeker asylum application has been lodged is then the country of the asylum application and so on. I hope that's clear. So it's not what we often hear, that the first criteria to determine which country is responsible is the first entry criteria, but it is largely the one which is the criteria, even sometimes wrongly, used by member states for deciding whether they are responsible for the Dublin application or not, for the asylum application or not. So how the Dublin application is actually, or these kind of criteria are actually checked, that's something we talked about already. This is a comparison with the different fingerprints. The so-called Eurodac regulation opened up a database, a Eurodac database, where all the fingerprints of those persons that have been identified as irregular entries, and it's, let's say, more easy in the hotspot areas. If you disembark from a ship, for example, in the southern part of Italy, and you go to a hotspot, then the registration and the fingerprints are immediately done, and then immediately available in the Eurodac database, which then is the sort of basis for deciding whether a person has entered through the European soil in a certain country. Okay, so that's very important to recognize this this Eurodac, the importance of the Eurodac system. We also have the European Visa Information System. This is also a database where all the visas are registered. So by checking both databases, you actually can easily understand whether these criteria you have seen before, 2 or 3, are basically fulfilled, and then you can identify easily from this database whether the certain country is responsible for the asylum application or another country, which is not, and this is something which creates some problems. Obviously, it is obviously not showing which kind of family member ties a person may have in another country. That's up of the discretion, or that's the obligation of the Dublin units to verify whether there are family ties in other countries, and that means that in this moment, and the other criteria, fingerprints or the visa information systems information is not sufficient. It's not important. You would then immediately call upon the first criteria, which is the family ties. Other documents we like tickets, passports, and all this kind of proofs can also be used, obviously, for the determination. And of course, all the information that is provided by the asylum seekers. Let me recall that the asylum, at least the last asylum 3, the Dublin 3 regulation, oblige the member states for a personal interview for the Dublin procedure. This is quite important because before it was not regulated in such a strict sense, and it happened in practice that interviews had not been taking place. Now it is an obligation. Asylum Dublin interviews are taking place in the asylum procedures, and this makes at least possible for an asylum seeker to present the different items on family ties, for example, or the problems of being transferred to another country in a certain way. There are some derogations. So, for example, you can look them up. For example, also the fact that a person cannot be deported and transferred because of a certain illness. Very importantly, the Dublin regulation has established a very complex system of deadlines, meaning that there are certain deadlines for the country of host of the asylum seeker to ask for a country to take back this person. So there are different deadlines for this, and you can after the deadline, the country of host becomes the country of responsible for the asylum application. There's also a deadline, which is the responsing deadline. If the country that asks to take over an asylum applicant, asylum seeker, is not responding in time after a certain deadline, the country becomes automatically the country responsible for the asylum applicant. And of course, all this can be overridden by the so-called entrance self-entry criteria, where a person can also be taken by the country of host because they decide on their own discretion to take take the asylum application for practical reasons, or for the reasons that they don't believe that in the country of first entries, for example, the situation for this specialized asylum seeker is sufficiently safe. There are a number of human rights implications. We do have a number of items that needs to be preserved. This has been enhanced by the Dublin III regulation. Beforehand, it was not as strikingly sad, because beforehand it was, I think, considered that as soon as you're in a European country, you're automatically safe. There was a sort of idea that European EU countries would not be a problematic country for the protection of asylum seekers and refugees. This has been overruled by a very important case, the so-called MSS versus Belgium and Greece case. Here we had an asylum seeker that asked in asylum in Belgium, but came through Greece. And in Belgium, the authorities said, no, Dublin regulations applying, we're sending you back to Greece. Greece at those times had, as it still has, a number of problems, for when you're talking about hosting of asylum seekers in Greece. This was made available as information to the Belgian authorities, but they nevertheless didn't really check any kind of the accuracy of those information and sent this person back to Greece. And the person again came in, let's say, in reception centers, which were considered with this judgment, for example, to be unhuman. So the European Court of Human Rights judged that this transfer from Belgium to Greece was not accurate, for the specific reason that the reception system and the system of protection in Greece is not in line with Article 3 of the European Convention of Human Rights, meaning that the conditions are considered by the judges in Strasbourg as non-dignified and non-human. So it's an unhuman treatment. A number of other rights that might be implicated with the, which is, for example, the right to family, which is also, let's say, one of the reasons why we have this strong criteria in the Dublin regulation that family members should live together and should also, there should be only one country for all family members that is responsible for the asylum application. And of course, there's also Article 5, which is the right to liberty, which sometimes is a problem because in cases of Dublin, we also have forced transfers, and forced transfers comes often with detention. And so a number of obligations towards this detention, obviously, are on the member states. There are a number of other rights that in the Dublin procedures are clear. What is important to highlight is that asylum seeker has a right to information in an understandable language, meaning translation needs to be provided. Authorities have to make sure that this information is provided. They have a right to see the files. That's a big issue in practice, by the way. It's very hard to get actually this asylum, the Dublin decisions from the Dublin units. I have seen in my practice different files from Germany, which are just emails in a certain way, claiming for not being responsible for asylum claims. Etc. Getting those files and getting there tangibly in a way that you can also make appeals against it is it's very complicated in the Dublin system. There are also a right, as I mentioned, the right to personal interview. That's very, very, very important, because that's the moment where if an asylum seeker is well advised, and if you are, for example, at some point or another, are in this position to advise asylum seekers in front of Dublin procedures, it's very important that the person is going with all the information beforehand received to this personal interview and provide all the information that an asylum seeker needs to provide in order to stop, for example, an asylum, a Dublin transfer. And of course, there are specific guarantees for an unaccompanied minor, etc. So how it works in practice? So you have so the Dublin units that have talk to each other. So the German Dublin unit, which is in this BAM for inside of the let's say the authority, which is also providing the asylum decision. So put in a very practical sense, for example, the German Dublin unit has identified in the Dublin, so the application came to their knowledge. The first check is that this person come after fingerprinting check, for example, come through Italy. Then they make a decision and make a asylum takeover request to the Dublin state, which is the first entrance in this case, in my example case, for example, Italy. And the request is to take charge and take the person back. So take charge of the asylum application and take the person back, meaning physically transferring the person to the country of concern. So there are specific deadlines attached to it. In practice, the transfer is either done voluntary, meaning you just receive a decision that you have to go back to Italy, and so if you go, then that's what's happening, or it is forced in a way that a person is transferred forcibly by flights, mainly to the country of responsibility for the asylum application. So. So if another country, and that's what you read in the decision as an asylum seeker, you read basically with the explanation, of course, but you read the decision is that the asylum application is inadmissible. So in the country where you apply for asylum, because of the fact that another country is responsible for your asylum application. So they have the right to decline the admissibility of the asylum application. And then the deportation to Italy, for example, is ordered. It has to take place, transfer within 6 months. Otherwise, if the transfer is not happening after 6 months, let's say in my case, Germany towards Italy, then Germany becomes again responsible, and the asylum application would then be done through in Germany. It's very important that these kind of deadlines are quite let's say very importantly set in the regulation, because it makes sure that after these kind of different deadlines, at least at some point, you know and determine which country is responsible. But secondly, you can imagine after these kind of different deadlines happening that the entire asylum procedure is prolonged through the Dublin procedure beforehand. So that's meaning that you have often a year before you actually go to an asylum application and the individual assessment whether you can receive protection, you go through a 1 year often Dublin procedure. So in all these months, you're just in a limbo and are not sure whether you can actually stay in a certain country and you receive protection. You can appeal against the decisions. You have some protection. And again, this prolongs obviously the entire process. but it gives you also some, there has been, for example, from Germany to Italy, there has been some important, for Germany again, after this MSS decision by the European Court of Human Rights, there has been important decision also by administrative courts in different countries, that Dublin procedures and Dublin transfers to Greece has been stopped, or towards Italy, for example, have been stopped. I give you some, and I will stop quite soon, but I would like to give you some examples how it works. I talk a lot about this example, Germany, Italy, because I have been specifically involved in different cases, Dublin cases between the two countries. So just I would like to highlight you from practice how actually it works. So basically, as soon as you're transferred, forcibly transferred from, so you have received as an asylum seeker, let's say you're a train asylum seeker coming through a boat to Italy, and then you go to Germany because you have a lot of family members, but not the right ones that would allow you under the Dublin regulation to do your application in Germany. So potentially an uncle or a brother or something like this. You go to Germany and you live with their community, your community, and you're a bit more safer in a certain way. And then you apply for asylum in Germany. German authorities reject your asylum application, saying it is inadmissible, and you have to go back to Italy because the fingerprints show that you have going through Italy in the first place. You don't want to go, so your voluntary return to Italy is not, you're not fulfilling it. So they take you at some point to Italy on a forced flight. And what happened is that mainly you arrive either in the airport of Milano or Rome, and then the nightmare starts, because usually you have to go where you have been assigned for the asylum application in Italy, meaning you have to go back to this to the province and the city where you have stayed in Italy. Maybe you started even asylum procedure over there, and but this is sometimes very tricky. You don't know how to go there. You have problems potentially to understand where you can stay in the first place when you come in Milan and Rome. You have no ties. There are some problems with the shelter, whether you can re-enter the shelter, asylum shelter, from your first passage through Italy. But remember that you may have already lived more than a year or maybe 2 years already in Germany, so you lost completely ties in Italy. Little information is available in all this kind of aspect. There are some organizations that are helping and giving some specific Dublin support, like, for example, there's the Protestant churches that have established in Rome a legal support system, but also a number of refugee law clinics or clinics in Italy provide some specific support for Dublin cases. Two small things that I would like to provide you is that Dublin can be, so for example, if Sudan, and this is happening in, so there are some expulsion cases from Germany to Sudan or from Italy to Sudan, and you have a Sudanese refugee asking for protection in the country, and you're not finding yourself, and you're knowledgeable about Italy or Germany sending back people to Sudan, then this might be a very important part of your defense against the Dublin transfer, because you can claim, obviously, that you may risk you're not safe in the protection provided in the country, the first country of entry, because transfers, for example, to Sudan are existing. So I want just to highlight because, for example, Italy and Sudan have signed specific agreements to return irregular migrants to Sudan, for example. There's a lot of criticism, and I'm not going through all them now because I would like to, we can touch upon in the discussions. The system is not working at all. It is not providing what it wanted to provide, more solidarity between amongst member states. It is more in practical sense creating a lot of problems. Taking the asylum procedure much more longer often. And we're talking about not just some weeks, but often about years. The wishes and needs of asylum seekers are not considered at all, not taking into consideration. As I mentioned in the beginning, in one of the questions, the European Parliament tried to change this. Fortunately, it has been blocked, this kind of discussions. It is actually more expensive. I'll come to it in a second with showing you some figures. It is not working at all. There are a number of cases that actually shows that rights violation by member states towards asylum seekers have been enhanced through the Dublin system, especially because you transfer a person forcibly, not taking into consideration their specifically problematics. Just some figures from 2021, from last year. You can see these are the numbers. So blue is the outgoing requests and incoming requests. These are, you can see Germany has fired a high number of requests, the highest number of requests to transfer persons back to the country of first entries. You can see also that Italy receives the most importantly the most highest number of requests, mainly from Germany, I must say. And the other ones are the incoming requests. You can see it like this. So you just comparing Germany and Italy, for example, you can see this kind of slipping coin, if you want. What it shows in practice, though, is that so you have Germany filing the most largest number of outgoing requests, and having Italy have the most largest number of incoming requests. Then also Italy and Germany made the largest number of decisions of incoming requests, which is interesting. But in the end, and that's very important, I would like to draw your attention to the actual transfers. If you see the transfers, France counted 3,000 transfers, outgoing transfers. Germany only 2,000 outgoing transfers that effectively have been transferred to Italy. And in the end, it actually, as you can see, although Germany has more outgoing requests, actually they take more people in than actually going out, which is quite striking as well. These numbers have to be cautions, obviously, because these are taking into consideration, I assume, only those transferred that are forcibly, so not taking into consideration all those voluntary transfers that people are going voluntarily to the country of first entry. Anyway, just finishing with Francesco Maiani saying this Dublin regulation achieves very little at very high costs, both for the protection of asylum seekers and the Italian system, if you want, and for the functioning of the entire common European asylum system. Just looking at the numbers, you can see that it takes a lot of time to take all those 45,000, almost 400,000 Dublin regulation procedures in Germany, but in the end, only for 2,000 transfers, which is actually a very little number. So thank you very much. And now open for discussions. Yeah, we have almost 20 minutes. That's not bad, actually.
Actually, there are some questions in the chat. Probably someone that I think you responded with the lessons about the Dublin regulation, but if someone have some other question, they can do online.
Okay, let's go through some. There was the question, I haven't answered this question. In an EU member state like, was there somebody speaking? No, I'm going to the question to Abu Bakar's question. In an EU member state like Greece, where young boys, for example, asylum seekers, were forced to engage into sex for food, can they consider it under the Dublin if they choose to move to another EU member state because they don't feel safe in Greece? Yeah, here the problem is, yes, they would be considered as soon as they would apply for, so they are, for example, in Greece now and have this kind of problematic, and then at some point they find themselves going through another EU member state, that would be Germany, that would be Italy, that would be France or whatever, then in the Dublin regulation procedure in Germany, France, Italy, or wherever, they may highlight this problematic and saying that they cannot be going back to Greece given the difficulties that they have experienced. That may happen, and that may be considered. Problematic is that there is no right attached under the Dublin regulation that the person is transferred to another country from Greece, given this situation. So the person should go autonomously to another country, and as soon as they find themselves in another country, there might be some good chances that the person gets protection and would not be sent back to Greece. But it doesn't allow, doesn't give not a right to a person to be transferred to another country when they're not one of those criteria be fulfilled, having family members somewhere else, or having a visa or somewhere else problematic, let's say visa in another country, from another country. I hope that was clear. I think there's somebody raising a hand. Maybe let's take this question first, and then we go to the other questions.
Nicole, you can speak, please.
Yes, my question would be, I know people who have got the deportation letter, and they are taken forcibly by police to airport, but they refuse to sit like on the airplane, or they refuse to leave. And I know two successful cases that the person refused to sit, and if there is any passenger in the plane who is not comfortable with the situation, the plane cannot basically take off, and then the deportation process, I don't know if it stops, but it's like it cannot proceed. So do you know, like I heard you say that I mean, it passes automatically and you cannot refuse, but probably on a legal way you cannot, but probably there are some other non-legal ways to refuse this.
Yeah, of course, in practice that is happening a lot, and of course it might be quite effective in some circumstances. So I would say in practice that might lead to the I mentioned in the slides in my talk as well that after 6 months of unsuccessful let's say transfer, the country of host would be responsible automatically. That's the Dublin regulation basically saying. So if it's not possible to transfer a person in this kind of time frame, then the country becomes automatically responsible for the asylum application. So yeah, basically in practical sense, if this is helping to let's say sit out, if you want, the 6 months, then potentially that might be happening in practice. But I'm not. But you know, it is a very harmful way to go through your let's say not applying to your right of because it is quite an active it's a sort of violent way to disobey, which obviously comes with a certain problematics as well, and often also a treatment by authorities in a certain way. So it is not it's not easy, and I would never suggest a person to do so in this way. I would certainly advise everybody to find all legal means to go through different possibilities to attack the Dublin transfer in a legal way, or finding at least a way to make the transfer as human as possible. But again, I can imagine that this might work in a very practical sense, and I've even heard stories that this worked out. I'm sorry, I'm not so sure whether this is helpful, but Katarina has also a question.
Yes.
Yes. Hello, can you hear me?
Yes.
Okay.
Yes.
I'm not sure if you already answered my question, but it was basically about if you think that the Dublin regulation doesn't put all the responsibilities and the burden on managing this complex situation on Southern European countries such as Italy, Spain, and also Greece, and what was the meaning behind them to sign this regulation? I mean, what were the reason for them, since all the burden is on them?
So yeah, I think when Italy, Greece signed the Dublin regulation, Dublin Convention, you have to remember it was in the so the convention was signed by Italy, I think in 95. So later they joined the Dublin Club, if you want, later. No, sorry, the Schengen Club, but the Dublin, I think, quite from the beginning. But anyway, what is, you have to remember those times. There was no boat people. There was no offshore refugees coming. There might have been only the situation of Albanians in Italy, but this was a very specific, let's say, situation at those times. So I think when you recall this, they didn't really expect that this happening in the same way as it's happening now. So I think it was not predictable for them so easily, or maybe it was predictable. But refugees of those time came mainly through different means, going to Germany basically often at those times. So this was, I think, and Germany was also one of those countries in the 90s, which was an external country, so on the external border. I think this was the reason. Now, why they didn't change it into a more practical sense, if you look, for example, what happened to the proposal of the European Parliament and why Italy has not accepted it, for example, under Salvini at those times. I don't know exactly, but I would expect, my guess is a bit, I think it worked quite well for some parties, let's say, to use the Dublin system, which is considered by Italy and Greece by not working and being more a burden for countries like Greece and Italy, by using this as a political argument that they always are the country who takes all the burden and all this kind of stuff. I think that worked politically quite well, and I have the impression that they might not have liked to change it easily, so that this argument is not usable anymore. But it's just, I guess, I don't know. Now this will all be online and you can see all my faces online. Okay. Other questions? Let's go through some questions. Oh yeah, I will put the link, and let me just check it, and put a link of the video of the forensic architecture. If you just Google this, you will find a number of very interesting ones. But I will try to find it. So Helena, you have 2 questions. Do you want to talk? Maybe Helena, we have two questions. You can make them.
She can.
Otherwise, okay. So, what are the benefits of the South European states signed Dublin? That was I answered already. Does Dublin apply for? I think there is no benefits basically at those times, at least. And actually, to be very honest, none of the countries actually benefit from the Dublin system. I don't believe that any benefits come from the Dublin system anyway. Does Dublin apply for EU states that are not in Schengen? Yes, Dublin is applying largely. Then, so Bulgaria, Romania, Croatia are part of the Dublin system. Okay. And yeah, they are using the same asylum system. So it was also asked. So as soon as you join the European Union, you have to apply the common European asylum system. There are some exceptions, like Denmark, as it has been at those times discussed. Denmark didn't want to join the common European asylum system, so there was a sort of exclusion. I don't believe that any new member state now would have the power to negotiate something like this. So that's not happening. So Croatia, Bulgaria, and Romania, when they joined, they immediately had the obligation to join also the common European asylum system. Alexandra asked a question: does the reunification procedure under the Dublin regulation, so family reunification, I guess, as far as adults are concerned, only concern children or spouses? I don't see any mention of siblings. Yeah, siblings are not. I mean, there are some exceptions. If you are, so it's only spouses and children. Children that are dependent, so not adult children. And what is important is that there might be some situations. That's the only kind of that can imagine. If you are specifically depending on a certain person, then, so for example, a handicapped person, for example, is depending on the assistance of a sibling or a mother, and you're already an adult as a child, for example, then also this family ties would apply. Okay, is responsible to transfer on a state or on the individual? The responsibility to transfer is well, you have as an individual you get you make an asylum application. The asylum application is rejected, not admissible, and you are ordered to go to the country of first entrance. That's what's legally happening. So you're obliged to go back to the country of first entrance. You're not obliged to go back to your home country, but you're obliged to go to the first entrance. Of course, you can go back to your home country. That would be without saying, of course. So the responsibility on this is clearly that on the individual to go back to the country of first entrance, or of the responsibility of the asylum application. But if the transfer is not happening, then of course it can be enforced, and then it will be enforced by forcible flight. I don't know if this is clear what I meant. Okay, if someone, Mathilde Bertrand is, if someone managed to hide and avoid the authorities during the 6 months, does this mean that, yeah, I mean, there will be, as you can see, I mean, the numbers of forcible transfers are quite low compared to actually what the requests are. Now, you're confronted with a situation where actually your entire asylum application is not enacted. So you get a rejection from the asylum applications authorities to that your asylum application is inadmissible, and you have to go to a country of first entrance or of asylum applications responsible for the asylum application. So this means that you can hide, of course, but it doesn't really help you going further. You know, you become irregular in a certain way. So it's not by hiding that you actually get any further with your asylum application. And why do people ask for asylum? In many places, it's because you do need protection. But sometimes it's also because it's the only kind of way to get a legal status in a certain, if you are lucky. So you use asylum procedure also because there are no other means for getting a permit to stay in a country. You use the asylum application in a certain way as a means to stay regular in a country. So in all the sense, it is very, you know, it's not advisable to hide yourself. It's advisable to make actions, legal action, and there are a number of legal actions that are available in terms of you know, going through against a Dublin transfer. But I think that's possible, but I think it's not really advisable because you're not going further with your asylum application. That's the problem, and that means that you hide yourself in irregularity. Is there any alternative proposed to rethink the current asylum system to avoid a border securitization? Yeah, let me say something something that won't rely on third countries at the same time grant the right to people to move. Yeah, so there are two kind of ways. One we talked about last week is the Ukrainian situation and the temporary protection system. Here for the first time, and I was really surprised when they published the temporary protection decision. They actually didn't enact the possibility which was foreseen in the directive for temporary protection, that you can apply only once temporary protection, a kind of system of Dublin in a way. Now, now they specifically opened up. There is a free movement. People, the Ukrainian, so let's say, all these refugees from Ukraine can decide where to apply for temporary protection in Europe, and they're completely free to choose. They don't have to motivate it, etc. I was surprised about this fact, but it's also showing, and practically speaking, that was the only way to get logistically the situation working. And I guess, and I hope that it shows that you actually, because without checking who is responsible, you go immediately to the assessment of the protection holder. So you assess immediately asylum application. So you become quicker in asylum procedures, and you can then provide quicker protection and more quicker answers to the integration issues that are related to it. Access to work, access to education, language course, and all this kind of stuff. So, so it's actually logistically in the interest of the states to go away with the step system. It's just it's just making the process of asylum much more longer in Europe, and it doesn't really help, as you can see from the figures. It doesn't really help you as a country to overcome your secondary movement problematic. Okay, now there are a number of other points at the moment. We have very little. So this is a sort of a sign of hope, I would say. That was just my idea. Hopefully, out of the next, they adopt similar sort of rules for Ukrainian refugees. As for the Ukrainian refugees, that would be my hope. And I hope that there are some other means for legal entries that are created. There are a number of discussions going on for more partnerships, partnerships with third countries out of the fact that a lot of European countries need migrants for the job market, which are at the moment looking for persons very, very strictly. And that might be an openness, an opener also for more legal ways, pathways to Europe. And then automatically people would less use asylum applications, and only those people who really need protection would use it. So that would be ideal. But this is something NGOs claim since a long, long time, and it's really happening. Okay. There's some other questions. Do you know who is leading the biggest and most important movement towards amending the Dublin system? The European Commission proposed in 2020 a new regulation. They wanted to get rid of the name Dublin regulation as well. So Dublin system, they wanted to reform it. At the moment, it is blocked with a number of other instruments in the negotiations of the European legislators. So I would say at the moment, we as civil society organizations or actors often refer more to the European Parliament to help us to amend it in a more practical sense. I think potentially that's the most fruitful, given also that the European Parliament had a good, well, better position, at least for the Dublin 4 proposal. Now we have a completely new proposal on the table, so it's more tricky anyway. But I would say European Parliament, yes. How long does the impossibility to establish in a member state other than the one who granted refugees apply? Basically forever. If you're not granted another, so there's no time frame. So let's say you are a refugee protected with a refugee protection in Italy, but you would like to work in and to transfer yourself in Germany. Then the only way to get to Germany is to ask a visa, a work visa or something like this to go to Germany. There are no other means. So that might be possible. I'm not saying that's completely out of the possibility, but of course it's much more tricky. And you give away your protection. Carlo.
Sorry for stepping in like this at the end of the lesson. I just wanted to add that an option is to apply for a long stay residence permit, EU residence permit, after basically 5 years after you applied in first instance for the international protection. So that's, I think, the best way to have the possibility to have access to the Schengen area of freedom of movement, with all the, of course, restriction that we have seen in the first class.
Yeah, exactly. Thanks, Carlo. Yeah, I forgot this to mention. It's true. It's not forever in a certain sense. You can, after a certain protection of 5 years, regular staying, apply for the long-term residence, and then there might be some possibility to transfer your status to you're asking for permit to stay in another country. Yeah, that's a good area. I tried to understand the question for Barney. In Schengen visa, there are 2 parts. One is for visa, one is for the stay. Should people wait 6 months after finishing duration of the stay or after visa? Let's say they give 12 months visa for duration of stay is 9 months. Which one is the correct item for Dublin? So I'm not so sure what you mean. So if visa and the permit to stay are 2 different items. So visa is just for entering, and then you have a permit to stay. So for example, if you get a visa in order to study, you still have to transfer. You're not you cannot stay with your visa alone. You have to go to the authorities and to ask the transformation into a permit to stay. As soon as you have a permit to stay, you can obviously stay until the end of your permit. As soon as you have problems to go back to your home countries because of prosecution, then it is advisable that you go immediately asking for asylum applications. So you go immediately, as soon as this occurs, this situation occurs, you go to the authorities and ask for asylum. If you ask for asylum, Dublin is immediately applicable in the sense, then if you ask asylum in another country, then the country you got a visa or a permit to stay, then it is definitely the country who issued the visa or the permit to stay who is responsible for your asylum application. I'm not so sure whether this is clear. So I'm not so sure about the deadlines implied here.
I think that if I understood the question right, I think that the answer would be, but I'm guessing, so I'm not sure either. I think the answer would be the duration of the visa. So in this case, 12 months, because it's the validity of the visa. The duration of stay is how long you can stay in the country while the visa is valid. So I think that the deadline goes from the end of the validity of the visa. I think it's like this, if I understood well the question, but
okay. So we hope we answered your question. Last 2 questions. Are there sanctions for Dublin states who refuse to apply the regulation? Yes, of course, there could be sanctions, but this is then the European Commission as the, let's say, safeguarder of the European treaties that could enact if somebody is not working well on the Dublin regulation, could make an infringement procedure against a certain country with also some sanctions. The other way would be that you go in front of the European Court of Justice in Luxembourg, and also here sanctions are not really the right term, but it could be that the decision by the judges in Luxembourg is clarifying the position of the obligations for member states, and then you can just hope that at some point at least the judges at national level are sufficiently empowering these decisions from the Court of Justice. Last point from Julia: can an asylum seeker apply only once in lifetime? No, you can apply for asylum different times, but of course, as mentioned already, if the situation is not changing, so if you applied for asylum in a certain time, and you considered and assessed through in this time of history of your life, let's say, what is the situation in the country where you come from, and you would be otherwise requested to go to, and but this situation may change, obviously. So once you have done the assessment and you have a rejection and the situation does not change, the country would always say, well, this decision is already done, and you cannot apply again with the same. So you have to provide basically new elements for your asylum application in order to make a new application. And it can be either your country has going through a difficult problem, that'd be Mali, where you have some areas of Mali which are not safe anymore. And let it be Ukraine at the moment, for example. That's a classic example. It was safe and it's not safe anymore. So situation change, and of course it might also change in the other direction. So a country may become safe, and your application is then rejected from the fact that your future assessment is not providing you the sufficient means for protection. So we're going through all the questions. I hope we answered everybody.